welcome. Thank you so much for taking the time to join. It's great, and Claire has shared the information about the Mediation 2020 conference in the chat. Delighted to have with me today a good friend, Jean Sternlight. I sent out her article, Pouring a Little Psychological Cold Water on Online Dispute Resolution. I think, many of us, because if we've gone through the trainings in the last year or two since Jean's article has come out, this is a very important article, so we often circulate this with trainees. But it's great to have Jean live here to talk with all of us. We want this to be a very interactive session. If you know anything about Jean, she's a legend in dispute resolution. Her expertise, she wrote a book on the psychology of, what was the title of the book again, Jean? The Psychology of Legal Practice?
It's Psychology and Lawyering. I'd have to actually look at it to get the exact title, which is embarrassing, but it's Psychology and Lawyering is the gist of it.
Fantastic. And Jean is was the founding director of the Saltman Center on Dispute Resolution at the University of Nevada Law School, UNLV. University of Nevada, Las Vegas. So it's a delight to have her here, and I'm really excited to engage in this conversation. So what I'd like to do is sort of kick it off and ask Jean some questions. If anybody has any questions they'd like to surface, please do so in the chat. But we'd like to save the bulk of the session for us to talk more broadly. Because I think when Jean, when you wrote the article, obviously COVID wasn't an issue. I mean, we were sort of seeing some of these trends emerge in the dispute resolution field, but we had no idea that we'd be thrown into everything that's happened over the last 6 months.
Yeah, that's for sure.
And Jean and I were just discussing as well, she's teaching classes online at UNLV as well. And what is it? Civil procedure, which is a big required, core course. So an interesting aspect of that is there's some parallels between teaching online and doing online dispute resolution. So we can talk a little bit about that as well. So why don't I dive in here? Let me change. I'm going to pin you, Jean. So I'm looking at your face. Okay. Pin video. Okay, great. I think that's recording. So Jean, let's walk through a little bit of the content of the article to sort of kick things off. And I know one of the points that you make at the start of the article is some of the imprecision around the term online dispute resolution and some of the challenges that can bring. So why don't you tell us a little bit more about that point?
Yeah, I mean, that actually, it makes me crazy. The first time I really started to think about this was in connection with a symposium, and you were on the panel and I was on the panel, and I was asked to speak about the psychology of ODR. And so the first thing that I tried to figure out, because it's not something that I had focused on hugely in the past, is, what are these folks talking about anyway? What is this ODR? And of course I, realized, I mean, it's such an incredibly broad term, right? It's everything from the chat boxes to online videos to, online, arbitrations, mediations. It could be, even, I mean, I quoted, in fact, an article that you wrote, Colin, where you said something like, any kind of technology plus
right.
Dispute resolution, which made me start thinking, well, I mean, it could be a mechanical pencil for that matter. I mean,
oh yeah, sure.
Everything that we do is in some sense ODR. And the problem for me with the breadth of the term is that those forms of ODR, I mean, each of them may be wonderful, but they're so incredibly different from each other
right.
that it's hard to come up with advice that would apply in all of those settings. I might be able to say something sensible about video conference mediation, and I might be able to say something sensible about using chat boxes, but they're completely different entities.
Absolutely. And again, now we're seeing the emergence of artificial intelligence. We're seeing the emergence of smart contracts and these sort of crowdsourced juries. So I agree with you. The spectrum has expanded enormously. And I think back to the 99, 2000, 2001 timeframe when we would have ODR sessions at the ABA Dispute Resolution Section Conference, and it was just Dan and Ethan and me, in a room. That definition of technology plus ADR was adequate because there was so little of it going on. But now that we've seen this incredible proliferation of techniques and approaches, I do agree. I think the imprecision of the term is an issue.
Yeah.
So the other point that I would make is, the algorithmic side of the field is starting to look less and less like traditional face-to-face dispute resolution. And the reason why we picked ODR as a framing was because we wanted to be very clear it was connected to ADR. And for a long time, ODR, the mechanisms in ODR looked a lot like the mechanisms in ADR, but now we're seeing completely new things that have never emerged, never existed face-to-face. So, and I think now there's work on refining that definition. And the National Center for State Courts, they're trying to define ODR as, I think, a public-facing space where parties, public-facing online space where parties can convene to work out a resolution by mutual agreement, which is great. It's a much more specific definition. But again, that definition is really tailored to the needs of courts. And it doesn't encompass things like artificial intelligence. It doesn't encompass things like algorithmic mechanisms like cyber settle. So I think those of us in the field, we feel some resistance to that definition because it's lopping off portions of the field. But I understand why NCSC is going through that exercise, because they want to be able to explain to someone what it is and why it would have value for them.
Yeah. Well, I mean, you know, what I think, I mean, I really think that people who are talking about pieces of the ODR field are going to want to disaggregate the term. I mean, I just frankly think that it's not very helpful to use such a broad term. And I had the same problem and have the same problem with the phrase ADR, which, you know, really doesn't make any sense, honestly. I mean, I'm, as you say, someone who's been in the field for a long time, and it's not that I don't like the components of ADR. I love all of the components, but arbitration, in my opinion, has a lot more in common with litigation than it does with mediation or negotiation. And I think the only thing that those different components of ADR really have in common with one another is that they're not litigation, and that's not much of a definition. So I think that it'll be useful, you know, it's useful to talk about, you know, court-connected programs that provide the public with access. That's great. It's useful to talk about, you know, using, as you say, the algorithmic processes. Those are great. It's useful to talk about how to use technology to aid, you know, in-person mediation or to do mediation online. I mean, all of those are great things. I just think disaggregating helps us to talk about them in a more sensible way.
Yeah, and I think as the territory covered by ODR expands, it makes sense to subdivide that territory so we can, you know, address it. The thing I like about ODR is that I think the term is defined by what it's not. You know, it's sort of like, well, it's an alternative to the courts. If you and I have a dispute and we decide to resolve it over a game of checkers, guess what? That's ADR. I mean, you know, like that, we don't study checkers as a dispute resolution mechanism, but if we can come up with an alternate path that's sort of encompassed, but that it's too broad. And what I worry about is the imprecision of these terms is going to lead to fuzzy thinking. I do think, you know, mediation and arbitration are not the same thing, but they do overlap. You know, we have meet-arb and we have evaluative mediation, and, you know, now there's arb-meet-arb. I mean, there's so many different ways that all these components can be combined. I think we need to come up with a much more specific, not necessarily definition, but almost framework of, you know, of all the different approaches that are being used. So that's an important area of scholarship and analysis that I think you identify that is very apt. And I'm sure participants on the call have some thoughts about that too. Merez says, if the use of any type of technology used by us is ODR, then people using just a platform to meet and who claim to be ODR experts are right to claim that they're experts. Well, she's saying she doesn't agree with that, but ICODR and NCTDR members know what is meant by this. The imprecision is a problem. So a lot of people now I see are saying, well, we do ODR, we use Zoom. And it's like, okay, well, Zoom is not an ODR tool. It's used for everything under the sun, from teaching elementary school classes to networking with, you know, your old colleagues in a social hour. So to say Zoom is an ODR tool, I think is kind of inaccurate, but at the same time, ODR can be done over Zoom. So this is a challenge for the field, is figuring out how to phrase what we do.
Yeah. Well, I think another reason that it's so problematic is that it distracts you from what you should really be focusing on. So I'm actually working on another article now that's also talking about psychology and dispute resolution, not just online dispute resolution, whatever that is, but psychology and all forms of dispute resolution. Basically, our gimmick is, you know, once we're done with COVID-19, God willing, it will be one day, you know, where will we want to go with dispute resolution? So today, you know, obviously we're doing tons and tons of things through Zoom, online, on the phone, or whatever else, and not in person. And everybody has seen that it's really been a jumpstart, as you said in the beginning. People who weren't already doing ODR, they're doing it like crazy now, and
Sure.
courts are holding hearings and even trials using video conferencing. What are we going to want to do when we have the choice again? Will we want to go back to in person or not, and in which situations? So I'm writing this again with my co-author Jennifer Robinall, and we're at the beginning stages, so I don't have a completed article to give to you, but we're starting to think about, what are the features that you really want to think about of these different dispute resolution processes. So one of them is the richness of the media. In other words, given a particular form of media, whether it's in person or video conference or text boxes, how many of your five senses, can you sense through that media? In person is the richest because you can smell, you can touch, you can hear, you can talk. Video conferencing is not as rich. You can't smell or touch, but you can hear and you can see, but you can't see everything. And then again, other forms of communication are, much less rich, like just texting or emailing back and forth. But that's only one of, the five criteria that we're going to start to look at. A second one is synchronicity. So, some of these forms of ODR are synchronous and some of them are asynchronous. And I know that everybody in your audience, knows all about that. Some of these forms of dispute resolution are private and some are not, and that makes a big difference. Some of them are more comfortable to people because people are more used to them, and that's probably going to change with time. We didn't used to be very comfortable, many of us, with Zoom, and now, like it or not, we're all getting a lot more comfortable with video conferencing. But I think if you think about those kinds of features, those are going to vary dramatically according to the type of ODR. So if you just call everything ODR, it doesn't help you to really think about those different features. And once you are thinking about those features, that is what's going to help you decide when is a particular approach sensible or not. And all of them are probably sensible in some situation. It's just a question of what do you want to use when. And if you are using a particular form, let's say you are using, an asynchronous, not rich, private form of communication, what are some of the suggestions either for courts or for attorneys or for users as to how to make that work as well as it can possibly work?
Yeah, I mean, your points raise several ideas with me. Jeremy asks a question here that I want to touch on. He says, Colin, I have a difficulty with your logic. Zoom is clearly a tool that can be used in ODR, which could not be used in a non-ODR context. If we start to restrict the definition of ODR to systems that have algorithms for analyzing disputes, then are we limiting the definition of ODR too much? So why don't we talk about that first? I mean, it may be that so many of the tools that we use, and I think this is apt with the point you made, Gene, we're designing systems to fit the forum to the fuss. And I think ODR systems designers, we need to look at the palette of communication options and decide which option. I want to push back a little bit because I think there has been in the traditional face-to-face dispute resolution field a sort of implied hierarchy where the richer the interaction media, the better. And the presumption is if we can do face-to-face, we should. If we can't do face-to-face, well, let's do video conferencing. Well, if we can't do video conferencing, well, let's do audio conferencing. And then sort of down the chain to sort of text-based because it's the least rich. Well, what I've seen in the ODR work that I've done is parties oftentimes will pick and choose the channel of communication that they think is appropriate to the issue that they're dealing with and their relationship with the other side. So, at eBay, we own Skype. And, there was a lot of pressure on us from the executives, use Skype to resolve disputes. And what we found is none of the eBay users wanted to video chat with their counterparty because they didn't have a relationship with them. They didn't want to have to do rapport building.
Right.
It's purely a transactional relationship. So it's fine for it to be asynchronous in text. And if you suggest that they use a richer medium, they're like, no, I don't want to do that. So it's interesting too. And I'll say one last anecdote, and I want to go back to Jeremy's point. I had a conversation with my friend Ron Kelly, who's a very experienced mediator out here in California, and he said he's doing all this Zooming every day, and at the end of the day, he feels kind of lonely. Like he doesn't feel like he's had that connection. He really wants to be in person with people, and he misses that. And what I said to him is, Ron, I just don't feel that. I'm Zoom all day. I'm talking with all the people that I'm interested in talking to all over the world. I mean, for me, this is a very rich and satisfying thing for us to be having this conversation. And at the end of the day, I feel completely satiated in terms of my human interaction. And I'm happy to just go downstairs and chat with my wife and decompress. But what does it say about my psychology that these online channels of communication provide that fully satisfying psychological connection experience, but for Ron, they don't? And I wonder about the younger generation too, who have lived with these online technologies from their earliest days. You know, I think, and this gets to the next topic that I want to touch on, which is the psychology of parties going through disputes. You said Zoom is changing us. We're getting more comfortable with it. And it may be changing fundamentally our own psychology of how we interact with other people outside of the dispute resolution context, which may be legitimizing the use of these types of channels for dispute related and empowering the parties to pick which channel they want to use to interact with the counterparty in resolving a dispute may actually be a very party focused, a very
Right.
party empowering thing to give them that kind of choice. So what do you think about all of that?
That was a lot, Colin.
Sorry,
But
I'm
but I
sorry.
will go back to something you said at the very beginning, which is, people, I would say, especially people in the ADR field, have tended to say richer is by definition clearly better than less rich. And perhaps it will surprise you to hear me say, I don't agree with that either. I don't think richer is better. It's just richer, and it may be better for some purposes, and it may be worse for some purposes, exactly as you explained in some of your anecdotes. I think that's absolutely right. That's exactly what Jennifer and I, the kind of thing that we're trying to explore in this article, is really look into, what does the richness get you? What does it lose? So we look at things like emotion and rapport, and how do those play out in a more rich or a less rich communication medium? How do those play out in a synchronous situation versus an asynchronous situation? And clearly, as I've heard you say at other conferences, and in your writing, there are some real benefits to asynchronous communication, that it can help people, process emotion more effectively. It can help people with decision making. It can help people be persuasive in ways that they might not be able to be as persuasive in an immediate synchronous setting. On the other hand, some people are better at the synchronous setting.
Sure.
Certain people are very persuasive, probably too persuasive. We might believe them when we shouldn't, in certain face-to-face or synchronous settings. So we're not going to get, clearly this is good and clearly this is bad for any of this stuff. That's really my ultimate point, is that we need to break it down more so that we can make more sophisticated choices about what approach is best in what circumstances, for which purposes, for which client, for which lawyer, because on top of all the other differences, it does come down to, as well, what's your purpose? If your purpose is, get things resolved quickly, cheaply, that pushes you perhaps one way. And if you have a different purpose of, building future relationships to be as, long lasting as they can, well, that might push you in a different direction as well. But none of these is the only variable, right? There's so many variables. It's a really complicated decision-making process, whether for a court, for a provider, for a neutral, for a lawyer, or for a disputant. It's people need to be thinking about a lot of things.
Yeah, and I think mediators are reeling from the complexity of making some of these choices when this has not really been a core competency for working in the field to say, what channel should I be picking for these various communications? So, let me actually, we're getting great questions into the chat. The second part of what Jeremy said was, regarding Jean's comment on what is rich or a poor medium, is it possible to argue that online, e.g. using Zoom, is more rich than face-to-face? For example, if we want to see all facial expressions. We can't see facial expressions for everyone at the room at the same time, but in a mosaic screen, we have arguably even richer data. So what do you think about that point?
Yeah, I think that's just a definitional thing about what does richness mean. No doubt Jeremy is right. You can see faces more clearly on Zoom than you could face-to-face. And a number of judges and lawyers have pointed out it's not only what Jeremy says, but you can see them more close up on Zoom, but also you can just have a face-to-face view, whereas a judge or a juror might only be seeing a side view of somebody who is testifying. So, absolutely, that's true. The people who have defined richness, which isn't me, I mean, it's psychologists who've done tons of studies from way back. I mean, they would still say that in-person is richer because it's just catering to more of your senses, right? It's not just a visual and an auditory experience.
Sure.
There's more to it. And plus, you kind of, at least the way cameras are currently working, see more of the complete person in person. So yeah, you can see the face better in Zoom, but you can see the whole body better, in person. Where it's really going to get interesting, where Jeremy's point would be even more valid, is as we, move down the road technologically to something like holographic, dispute resolution. And then you really are starting to, wonder, what would that be? Because then you're going to be, seeing the whole person, the whole environment. Still wouldn't be as rich because there's no smell and there's no touch. But
I'm sure someone's working on that right now.
Sure. That's right. Yeah, absolutely.
Right. Yeah. I mean, one of the things that we've seen, and actually there was an interesting article written by an experienced mediator out here in California talking about how technology is transforming the dispute resolution process. Because it used to be, obviously technology would evolve to meet the needs of dispute resolvers, but now it sort of feels like dispute resolvers are evolving to leverage the capabilities of the technology. And one of the things that we've seen, because it's so easy to convene an online meeting, is that mediations are turning into many shorter meetings. So it's not sitting down for 2-3 hours with a mediator. It may be a series of 4 or 5 30-minute meetings. And again, what you said, and you make this point in the article, I want to make that clear. It's a false dichotomy to talk about synchronous versus asynchronous or online versus offline. What we see mediators do is they'll have a 30-minute meeting with the parties and say, why don't we think about this? Let's take a break for an hour. And why don't you, we'll consider, and why don't we do 2 caucus? We'll have private conversations during that hour, and then we'll reconvene in an hour. So you're mixing in a little synchronous, asynchronous, letting parties be a little bit more reflective, because it's so easy to meet and then break and then meet again. And over the course of 2 or 3 days, you can have 7 or 8 meetings to get to a resolution, which you would never do face to face. I mean,
Right.
it's just, so these new capabilities are changing the very way we think about the best practices around how these operate. And as you say, we still have to figure out what's effective and what's not effective.
Yeah. I mean, I think, I titled that article to be provocative, but it's not ideally explanatory of what I really think. I mean, it's called Pouring a Little Cold Water on ODR, which makes it sound like, I hate ODR. And that's not really what I'm saying. What I'm really saying is we need to use the psychology to better understand ODR, various kinds of ODR, and what works well and what doesn't work well in what circumstances, and how can we best use all the technologies. I mean, I'm not anti any of these technologies. I mean, I think they all serve good purposes.
Yeah, anyone who reads your article gets that. I mean, like I said, any constructive criticism should be welcome, and it's not even criticism. It's like, these are the things that we need to think about based on my experience. Brian asked a great question, or he made a good point. He said, in some Zoom mediations I've done lately, parties have requested that video be turned off. In a very few, parties wish to be isolated in breakout rooms from start to finish, never directly seeing or hearing each other except through my past messages. Medium is a spectrum, not a discrete method. This actually makes me think of, in California, a lot of lawyers are, going to jams and they're doing a no joint session model, again, and sometimes that's what parties want. And if we give parties a lot of self-determination in designing the process, they may say, look, I just want to shuttle. I don't want to see this other person. I don't want to interact with them. So what do you think about that dynamic?
Yeah, I mean, that totally makes sense that people are thinking about that, and they should be thinking about that. That really goes back to what I was saying a few minutes ago, where I was saying we want to think about, as best we can, what are the key features of all these forms of dispute resolution. And one of those key features was privacy, and another of those key features is whether a particular proceeding is transparent and or recorded, which are kind of the same thing, basically said different ways. People care a lot about both privacy and transparency and recording, but they don't always necessarily either want it or not want it. It affects them, though. It affects them, how they're going to be willing and able to communicate. If you think a proceeding is private, that may make you more willing to say more. If you think it's supposedly private, but you're unsure if it's really private and somebody might be sneakily, recording you, that's going to make you behave a different way. On the other hand, some people, they want their equivalent of the day in court. They really want there to be a record. And if there's not going to be a public record of some sort, then that will prevent them from being as informative, as they otherwise might, or from sharing all the information that they might want to share. So again, these are not factors that you can necessarily predict. They'll always point one way or the other. But I think it's great that mediators and providers are thinking creatively about how to tailor these tools, along similar lines. Courts, which are now using the technology, are starting to think about, oh, okay, so this Zoom stuff is pretty cool and video conferencing is pretty cool. Historically, court proceedings have always been synchronous. That's what an in-person court proceeding would be. But there are actually people who are thinking about asynchronous court proceedings, right? I mean, you could have, a plaintiff's attorney's opening statement recorded, and that need not be, taking place at the same time or even close in time to a response by a defendant. And similarly with, witnesses' testimony and so on. And so we can really play with synchronicity and privacy and recording and try to figure out which of those features make sense when and why.
Well, and again, we talk about asynchronous communications enabling parties to be at their best, be more reflective, be a little bit more thoughtful and circumspect in the way they respond. And you're right, synchronous interaction, oftentimes, that's when the emotions bubble up. I mean, at least in my experience, when I've been in a tense negotiation, sometimes I behave in ways that I regret because I get emotional and I have to react in the moment. So obviously there's the documents only arbitration and things like that, where the entire case is administered through text. But I think there's someone made a comment, let me see who it was. They said, Richard said, Zoom can be asynchronous by using many private meetings separated by days. So you can actually give people the time to reflect while at the same time having the quality of that in-person interaction. Yeah. And also, I think it's very interesting to be able to coach someone. So to be in a private caucus with someone and say, hey, look, what do you think you're going to respond with? Well, I think I'm going to respond with this. Well, you said at the beginning you wanted to achieve this, that, and the other thing. Like, how do you think that response will be heard by the other side? It's very difficult to do that in a purely face-to-face context. Yeah. Chuck said, as schools are encountering, online communication and learning are a different experience for students and teachers, and in some respects less comprehensively and personally collaborative and satisfying, and what they may find relevant to virtual and in-person communications in dispute resolution. I think this gets to what we were talking about before about some of the parallels between online instruction. I mean, obviously mediating someone is not like teaching them or training them, but there's an element to that, sort of walking them through the process. I also think, I wonder about how the psychology of younger people is being changed by this process, who are at a very formative stage in their development, and all of their interactions are happening via video. If we talk about the younger generation being comfortable with technology, this new generation may be dependent on technology, even leveraging some of these dynamics that Chuck mentioned. So what are your thoughts about that?
Yeah, I mean, I find, it's fascinating for me, of course, because now I'm trying to teach online. So I'm able to draw on some of the psychology that I've been reading about for my research and try to apply it to my own teaching. So, that's a lot of fun. And there are a lot of commonalities. For example, attention. People, maybe you're the exception, Colin, but most people just find it really hard to be as attentive to a screen for any kind of long period of time as they might be in person. And I think so far the research shows, that's true for kids too. And it's a real challenge, of course, for, teachers and online learning and so on. It's, it may be, some of this is apparently brain science, where our brains have evolved for us to want to, for example, look people in the eye. And they've evolved for us to want to look for body language expression. And when we can't get what our brain is telling us we need, it both makes us inattentive and it makes us tired. So, there's all these million articles about Zoom fatigue and so on. Those are important things to think about, as is rapport. I mean, I would say, the attention, the fatigue, and the rapport are, to me, some of the most fascinating features of both online teaching and also some forms of online dispute resolution. And it doesn't mean that online teaching or online dispute resolution is bad. It just means if you're using them, you've got to be really attentive to those issues and try to figure out ways to make up for it. So I have, to some degree, changed the way my class works. I'm still doing it synchronously, actually, online. So I have a synchronous online class, but whereas my class used to meet, twice a week for 2 hours at a time, there's no way I could, a wonderful teacher as I think I am, I cannot keep their attention for civil procedure of all subjects for 2 hours at a time. So now I'm teaching it 3 times a week for an hour and 20 minutes. And I have fewer students than I would have had in person, partly so that I can do some things to try to get more student involvement. And I'm using some other tools like the chat, and I'm using some other kinds of things to get student involvement in ways that I wouldn't have done in person, where I could have, looked out to see, are they asleep, and called on them individually. So it's not that it's necessarily a good or a bad, it's just that you've got to figure out how to adjust. But the rapport thing is a real challenge, right?
Oh yeah, absolutely.
And I think that's why, you don't have that craving, but as much as some people maybe, and maybe it is partly a comfort thing, but a lot of people just feel like they cannot get that rapport, looking at a screen as they could have, with the person sitting a few feet away from them on a couch. And I don't think we entirely really know what that's about yet. I mean, I'd love to see more research myself on, what really is going on with rapport. Because if we knew more about what's going on, it could help us to cope with it better.
Yeah, I was reading about something they call the online disinhibition effect, which is people are more willing to say things online that they would not say face to face. And
Flaming.
some of the, I'm sorry?
The flaming phenomenon.
Yeah, flaming is part of it, but it's interesting because I think what they say is, we're socialized when we're interacting with someone in person. If you say something that's hurtful and you see that register on your face, you have emotional reaction as well. There's a rational reaction, but an emotional reaction. It takes a certain kind of person to be able to say something hurtful to someone, to see that register on their face, and then for them not to back down,
Right.
And I think we're socialized with manners from a very early age, but I think this distance that we have online, this kind of emotional distance, it sort of enables a little bit of, I wouldn't say it's cruelty, but you don't register the emotions in the same way. And I think that
Right.
there is documented studies that show that encourages people to be, not necessarily just hurtful or flame extensively, but to say things that they wouldn't say face to face.
It also encourages lying. I mean, there's a
Yeah,
lot of
that's
studies
true.
that show it encourages lying.
That's right. Or excessive honesty, sometimes, which can be even more hurtful. When you say something that's very hurtful to the other side, when you would never say face to face, but online you say it. So I do think, I have heard from mediators, interestingly enough, they say this Zoom exhaustion is an asset for them in mediation, because the parties don't want to go on like for 8-10 hours. They won't stonewall as long, because you're right, 2 hours on a Zoom will just turn your brain into pudding. So people say, okay, you know what, let's just wrap this up, let's just do this, let's reach a resolution. So again, I think we're exploring some of the advantages and the disadvantages of the online medium, and it's shaping the way that we actually do the work that we do, which I think is
Although the exhaustion thing takes me back to that point that I had raised a while back, which is, what's your goal, right? I mean, if your goal is get a settlement,
right.
Then yeah, that's good. You wore them down, they all settled, it's done. If your goal is to get a good settlement, a fair settlement, have people, wake up the next day and be happy, maybe that's not such a good thing.
Yeah.
But for sure, it's a phenomenon. There's no doubt it's a phenomenon. I mean, the exhaustion is, it's very impacting, and it will have that impact that you described.
I will say one other thing, and I want to go back to the questions. So we have so many good ones that are being put in the chat. But Ethan and Leah Wing and Jan Martinez, I just finished an article for Negotiation Journal, and we're talking about negotiating agents. And we're talking about how people are now empowering little computer programs to sort of negotiate on their behalf.
Mm-hmm.
So you see this happening on the corporate side, but you also see this on the consumer side, where you can go to a website like Do Not Pay, you fill out a form with your information, and then you make a little robot that's going to go off and negotiate on your behalf. Now, sometimes these
Fascinating.
robots behave very, inappropriately. I mean, they just kind of bash on the other side until they surrender. But if we get into a world, what I found at eBay is people really do not want to confront the other side in a dispute. They will go to great lengths. We're seeing this in the eviction crisis. Tenants will contact a mediator and say, I'm terrified that they're going to ask me for all this money and I can't afford it. And then when the mediator reaches out to the landlord, they say, oh, I'll forgive all the rent. They just never asked me. And it's
Mm-hmm.
because people are so reluctant. We see this in calling, customer service as well. When you pick up the phone to call Comcast, you just feel this anxiety. Are they going to try and roll me? Are they going to try and take advantage of me? So I think part of escaping that unpleasant experience is offloading it to technology and having technology
Right.
kind of act as your agent. That's kind of what people do with lawyers. Like you be my aggressive negotiator and bring me back proposals and I'll say yes or no. But I think that's another interesting aspect of how we can remove ourselves from an uncomfortable place and use
Right.
technology sort of as our agent. And I think we're going to see more of that as we move forward.
Yeah. Yeah. Well, the technology, yeah, and especially with the younger generation, no doubt that they may feel even more comfortable with the technology. I mean, just look at all the people who now would prefer to check out at the grocery store, using an automated machine rather than
Right.
have to, goodness gracious, smile for 2 seconds, with the clerk. Or telemedicine is making the same discovery, right? I mean,
That's
there's
exactly right.
definitely people, probably more younger people, who will disclose more in a telemed context, either to a person that they're Zooming with, or maybe to a robot who's asking them questions,
Sure. Yeah.
artificial intelligence. Because yeah, there can be greater comfort. So yeah, it's fascinating.
Yeah. Okay. Well, let me get back to the chat because there's so many great things here. Lucia said, people say they don't want to see the other person, but we as mediators know from experience that in many cases, not all, it's pushing through that discomfort and getting to the deeper level of understanding that can be the path to resolution. So how much do we nudge parties to give it a try? Uh, Often people have to get out of their comfort zones to make progress. So what do you think about that?
Yeah, I mean, I sure don't have the answer to that. I mean, as you were saying, some people would rather not see each other. That's true. There can be advantages to asynchronous. That's true. But I completely agree with, was it Lucia? I didn't see
Lucia,
the
yeah.
comment. Yeah,
That's right.
Lucia's point. I mean, obviously, we've also seen that sometimes people can greatly benefit by being with each other in the room and realizing that the other side isn't the ogre that they had thought, realizing they have things in common, realizing they can make that new business plan. I mean, this is, what facilitative mediation can be all about. And I believe that can be best. So we're really just going to see the same debate that we've had for many, 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 many years about different forms of mediation.
Hmm.
It plays out with the technology too, right? But it's not either or. So folks who have found that in a particular situation, given these particular parties, given their issues, given their personalities, given their goals, one approach or the other may be best for them. And as you said earlier, you can combine different approaches too.
Right.
So I sure wouldn't say it's always best to always have everybody together, no, nor is it always right to have everybody separate. It's going to depend on the people, the circumstances, and everything else.
Well, and I say mediators are advocates for the process, not for a particular outcome. So it may be that we need to say, okay, you know what? We do need to have a joint conversation. And you may be reluctant to do it, but I'm going to coach you and we're going to get through this. And this is the right thing for the case. Meyer asked an interesting question about the ramifications of being able to see yourself,
Oh
your own
yeah.
facial expressions. I'm wondering, has there been any studies about that? I find that profoundly destabilizing to see a picture of myself. I try and hide that as much as I can or ignore it. Yeah.
Yeah, that was an insight for me. As a relatively new Zoom user, I had not realized that I can hide my own picture. And once I learned that I could through my research, that was delightful because I don't like looking at my picture. But more to the point for the questioner's question, there is some fascinating psychological research, not probably yet as much as there should be, that absolutely people are impacted by not only whether they can see themselves, but whether they know that they can be seen. So it kind of relates to the flaming stuff you were talking about before.
Hmm.
It's not just whether a person can or can't see the other person who they're saying something maybe derogatory about. It's also whether they believe that they can be seen by that other person. So whether we see ourselves, I think, relates to whether we think somebody else can see us. And when we think somebody else can see us, that makes us behave differently than when we think nobody can see us. It would be different in terms of credibility and probably in terms of, how we express emotion.
Yeah, I mean, it's very relevant. There's a great conversation happening in the chat. I can't summarize it because it's going to take all the rest of the time. But one of the points that Bob made is he said, I think Gene made a great point. I still start most mediations with a joint session. One reason is to give the lawyers and clients a feel for how their opponents will fare in court and to become familiar with the process, though your mileage may vary. And another point was from Chuck. Some accomplished ADR practitioners like Barbara Sharp and Tim Offer with Pax Republic in Australia are building amazing AI-assisted platforms for large multi-stakeholder facilitation problem-solving processes. I think that, this is, again, this concept of the fourth party and our expanding comfort with the partnering with the fourth party. I think some mediators feel really threatened by the fourth party as it gets smarter and more capable. And the notion that we would say in a dispute resolution process, well, let's go see what the fourth party says about what a fair resolution is, that it does feel like you're ceding your role, you're ceding your authority to this outsider. But at the same time, the power of that is expanding rapidly as well. So that may be something that, that parties and mediators get more comfortable with over time, is the role of algorithms in figuring out. And I think one of the things that you talk about in your article is the journey, the emotional journey of a dispute resolution process is important, separate and apart from the actual resolution itself in terms of the facts and the data and the details. But are we going to be willing to cede some of that to an algorithm? And when the algorithm says, well, this is the best outcome you can get, is there a vision where we will have satisfaction with that? Like that will be more emotionally satisfying for us than sort of the salami slicing. So
yeah, well, I think again, it depends upon our goals. And, there's so many attributes of dispute resolution processes that matter to people, but one that seems to matter is what the psychologists call procedural justice. So procedural justice is the idea of, people want to be able to tell their story. They want to be able to tell their story and feel like somebody heard them and treated them with respect, even if they lose. Now, I don't know whether an algorithmic process is going to give people the feeling that they had procedural justice. My suspicion would be probably not, but probably people don't care in some situations. So I might be willing to not worry about procedural justice if what we're talking about is my, return of my broken bicycle to Amazon. And then again, if we're talking about, I've been accused of a crime or whatnot, or I've been a victim of a crime, I'm going to feel quite differently about an algorithmic system. And obviously, with any algorithm, with any computer system, it's going to be a huge question of, who programmed what into that decision-making entity. And using the old programmers saying garbage in, garbage out, I mean, that's as true today as it was when whoever invented that 50 years ago. Could be a good algorithm, but even if it's a good algorithm, somebody programmed it, and that somebody's goals may not be the same as everybody else's goals. Or it could just be a flat out bad algorithm where a lot of people would look at it and say, wow, why is it that certain people are always losing or certain claims are always losing, and this, that, and the other. So,
well, and the thing about
problems.
Machine learning and artificial intelligence is we don't even know. We give a bunch of data to an algorithm, it comes up with its own rules, and then we give it new cases and it says, well, these are the fair outcomes. So, like we can't even understand, it's beyond human comprehension to know the rules that the computer has crafted itself. So we can only evaluate that, not as procedural justice, but as evaluating the outcomes. And of course, the justice of certain outcomes is in the eye of the beholder. You may have one algorithm say, okay, this is a fair resolution. And one side will say, that's too generous to the complainant. The other side, well, that's too generous to the respondent. So I think it's going to be difficult. It's going to be a long process through which we gain trust in these algorithms. But there have to be mechanisms through which they're audited and monitored and reported on, so we can systematically evaluate the outcomes to make sure that they are delivering justice. So. All right, here's another great question from Thomas. He said, I would be interested in hearing Gene's thoughts on amending mediation agreements to cover all these points being discussed today. particularly the ramifications that are related to video interaction. So we do have some model mediation agreements that we've shared and evolved that have integrated in some of this online stuff. But in terms of disclosures to the parties up front, is that something that you've thought about at all? Like in terms of, what would be important questions to ask parties to make sure that the online dispute resolution flow that is provided to them, meets their particular psychological needs in terms of.
Yeah, I can't say it's something that I've thought about. I mean, the one that jumps out to me, of course, is the recording issue that
Yeah.
people have already mentioned. So
Mhm.
whether it's in the agreement or whether it's discussed, obviously there'd want to be a good understanding of, is anybody recording this? I mean, the problem with recording is, is we all know how to hit the record button on Zoom. And if you hit the record button on Zoom, everybody knows you're recording. But nobody knows if I might have my, phone right now filmed to, capture the screen. So
Mhm.
you never can be safe from that. But I think that the person in the chat is right. At least you could, in a mediation agreement in writing, have people agree that if anybody ever does make a recording, that recording could not be used. And then you'd have, some contractual protection. I would
Absolutely.
say that's something where probably you and a lot of folks on this call have a lot more expertise than I do, is exactly what you'd want to put into an agreement.
Yeah, and we are working on that. No matter how much technological security you throw at a platform to ensure there's no unauthorized access and, X, Y, and Z, it's encrypted. You're right. Somebody could just hit record on their phone and put it underneath their monitor right next to their speakers and record everything. But, that can happen in a face-to-face process too, where people put it in their lapel
Right.
pocket and record everything. So we do have to rely on our parties a little bit and just being clear with them up front about some of those expectations. So we're getting near the end here. And there's so many different questions that I was going to ask, but I think the conversation is great in terms of where it's led us. You make 4 recommendations at the end of the article. Can you summarize those a little bit, and then we'll open it up for people to ask their final questions. We got 10 minutes left. So I know
Okay.
I joked with you last night. Remember, let's share your 4 recommendations, and you were like, "Boy, I got to remember what those
I
4
got to
are."
remember them.
Yeah,
I've got them written down. I look back at them. I'm like, well, that was pretty good. That was a pretty good article. All
yeah,
right. So my first recommendation, I suspect, is non-controversial. It's just, that I think everybody who is designing these systems, whether it be a court or a provider or a neutral or a lawyer or a disputant who's getting into it, they should think about some of the background psychology. So we've only really touched the surface, but there's so many really fascinating pieces of psychology that come into this. And, too often it's tempting for people instead to just say, oh, well, what's going to be quicker, cheaper, or, are we going to settle or not? And I'm simply saying, you should be thinking about things like, rapport and persuasion and fatigue. I mean, all of this is, relevant stuff. So that's really my first point, is let's think about the psychology as we try to design these processes.
right, right.
My second point is probably going to be somewhat more controversial in this group, which is, and it's not entirely based on research because there hasn't been enough research, but it's really just my own musing that sometimes I think today we're tilting too much towards certain forms of the technology, like the text boxes, that don't adequately allow the human aspects of dispute resolution to come through.
Mm-hmm.
So humans, like to express themselves emotionally. For humans, rapport is important. For humans, empathy is important. Humans care about, nonverbal communication as well as words. Because of those human aspects of dispute resolution, I think currently forms of dispute resolution, whether they're online through video or offline in person, currently allow us to capture more of the human aspects of dispute resolution that can be very important. And I agree with your point at the very beginning. I mean, there's some kinds of disputes where, you're returning a small item to Amazon. I don't care if I get to talk in person to the customer service thing. And like most of people, I'd rather not. And it will take forever to get a human. So, I just as soon fill it out online. But for other kinds of more personal disputes, I think we need to keep humanity in dispute resolution, whether it's humanity in an online form or not in an online form. So that's my second point, is keep the human aspects of dispute resolution where we need them. My third point is maybe a little bit in tension with that, which is to say, we really have to remember and remind ourselves that the technology is evolving, and it's evolving really quickly, which really, it's not just that the technology is evolving, it's that we're evolving too. And you made this point earlier. So, the technology is evolving, meaning, something that we currently think is completely almost hard to imagine, like holographic dispute resolution, maybe that's not that far away. Just like 10 years ago, they wouldn't have been able to imagine what we're doing right now. So as we're starting to plan, we need to remember that forms of dispute resolution are going to change a lot. So those human aspects, for example, that I currently think maybe it's hard to capture some of the humanity with technology. Maybe it is right now. Maybe I'm right about that, but maybe it won't be in just a few years, as robots get better and better, as we start to use holograms, as video conferencing technology improves and we have different kinds of cameras and camera angles and we can capture the whole body, it's going to be different. So we need to remember that, and we need to remember that we ourselves are evolving too. So, whereas right now everybody gets exhausted trying to Zoom, maybe our human brains are going to adjust. Maybe in 5-10 years they'll be looking back and saying, what was the matter with those wimps? This is easier for us than person to person. Person to person's what it's exhausting, because we feel so much pressure of being close to somebody and we can't stand it. So the technology is evolving and we're evolving. And then my fourth point is, notwithstanding that I've given you recently and earlier today some of my kind of instincts and impressions, as much as we possibly can, we need to be making these analyses based on actual data. So psychologists and others have been trying to do some studies on how do these different forms of dispute resolution play out. And boy, would it be great to get more information and more time for everybody to look at that information rather than just go by each of our instincts, because instincts can be helpful and they can also lead us gravely astray.
Well, all four of these recommendations, I think, are dead on, and that's one of the reasons why it's so great to have you talk to this group. But that last point in particular, I think we need to have a lot more data. I think right now we're making a lot of these decisions based on impressions and anecdotes, but I think it's great. Like Pew is funding these longitudinal studies of ODR in the courts. Again, as an ODR platform designer, I don't have that. I don't have 10 years of data looking at this to see what, and I can't do A/B testing of volumes that are happening off my platform and on my platform. So I couldn't agree with that more. We're running out of time, and there's so many great questions in the chat. I even wanted to open it up so people could ask voice questions, but I'm not sure we're going to get that. Chuck asked a question about implicit bias, and is there a way that we could use technology to help combat implicit biases, because that's a major challenge for face-to-face neutrals as well. So
no, it's a great point. Actually, it's a great point. Orchestras are doing that right now, right? So when orchestras hold auditions, not all of them, but some orchestras these days don't any longer have the judges look at the musician, because they know that if a person is looking at the musician and they see, oh, it's a young woman, maybe they won't think she's as good as an older man at playing the violin. So similarly, for sure, we all have implicit biases, and those implicit biases are triggered by what we see, what we hear. So if we're just using words, then those other biases are not going to be triggered. So that can be a benefit. That can be a benefit of using text-based forms of communication that are less rich, because the richness of communication can allow those biases to out. But on the other hand, there are other benefits of the richness. So, once again, it's not that you could say, well, therefore, never ever should you look at somebody. That's probably too extreme. But maybe there are some benefits, or there are potentially ways that you could use technology to, make everybody the same color, or make everybody's voice the same, or things like that might try to take away some of those biases.
Yeah, and at eBay, for instance, we didn't share information about, you never saw a picture of your user, you never saw their name, you never heard their audio. It was only their public reputation that you could see. And we had large communities of, for instance, disabled users who said, I would have a hard time getting a job at McDonald's, but I've built $1 million business here because no one can judge me on the basis of my appearance. So it's interesting. I think Chuck has made a couple other points in the chat talking about how maybe technology can help us overcome some of those cognitive limitations and biases that we may have, in our, even in our subconscious, which is interesting. Yeah, so we have to be cognizant of the challenges of technology, but also be open to some of the promise and potential.
Absolutely.
Yeah, I mean, if Google eventually invents an antenna we can screw into our heads and just communicate telepathically, I don't know, it's going to completely reinvent the way we reach empathy. And it's creepy to think about, but maybe over the long run, it could help us surmount some otherwise insurmountable cognitive limitations that we have.
Yeah, maybe. Yeah, I mean, there's a tension, right, between the biases are bad, but the rapport is good. And I don't know, how you get one without the other. It's a challenge.
Absolutely. Well, there's tons of great compliments to you in the session. Paula said all great points. It's obviously we need more data. Thank you, Jean, for expanding your thoughts and sharing these discussions. Very much appreciated. David said great session. Chuck said Colin and Jean, after the session, might you be able to send links and articles that you consider helpful? Definitely, I'll share some links with folks if you have some other ideas as to good articles on the psychology of dispute resolution. That would be great. Also, we have Kate, who I've done some work with in New Zealand, particularly looking at some of the values of the Maori population and how that can be integrated into technology, because they have some obviously long-standing traditions that put human connection and rapport building at the center of all interactions. So do take a look at the chat, because everyone's posting some very nice things.
I'd love to.
Yeah, we are at the end of our time.
I'd love to look at the chat. Are you going to save the chat? Can
I will. I will. I'll save the chat and I'll share that with you too. But I do want to respect everyone's time. Jean, do you have any closing comments and remarks you'd like to share?
Only that I've really enjoyed this, and I really have enjoyed, getting to hear just a few of the questions and comments from the audience. It's obvious you've got a, an incredibly, sophisticated, well-educated audience, and I'd love to learn more from them, which is why I'd like to look at the chat. So thank you for sharing that with me.
You bet, will do. So thank you so much, Jean. This was really great. I've recorded it. I'll edit it down and run it by you, and then I can share it more widely with the community. But thank you so much. You've given us so much great grist for the mill. And as we refine the ODR field, you got a lot of the leaders of it on the call here. We want to keep your concerns very close, top of mind and close to our hearts. So thank you so much for your great work. Okay, with that, everyone, please unmute. Feel free to say thank you and welcome to Jean. And with that, I'll set everyone free. Thank you so much for taking the time today.
Thank you so much.
Thank you.
Thank you so much.
Very much.
Thank you both.
Thank you very much, Jean. Thank you, Jean. Good to see you.
Thank you.
All right. Thanks, everyone. Stay well.
You as well. Good to see all of you. Bye.